Hey guys, you may have watched my previous videos on the Court of Appeal case of RDC Concrete and Sato Kogyo, where they laid down three situations of repudiatory breaches. Situation 1, Situation 2, and Situation 3A and 3B. So today we are going to talk about Situation 2, which deals with renunciation. Renunciation simply means that the defendant, the person getting sued, says, no, I don't want to fulfill my obligations in the contract. So, if the defaulting party, the defendant, communicates his intention not to perform his obligations before the time of performance, then it would be called an anticipatory repudiatory breach. Why anticipatory? Because it happens before the time has come for performance. For example, if A enters into an agreement to sell shares to B on the 8th of July, completion of the share sale is to take place on the 8th of July. On the 1st of July, someone offered A a higher price, so A tells B, no, I'm not going to sell you the shares anymore. So it has occurred 7 days before the actual date of the share sale. So that will be considered an situation 2, anticipatory repudiatory breach. For repudiatory breaches, the test is not subjective. The court does not look at what the defendant thinks. Okay, it is an objective test. The test that the courts will use to ascertain whether the action of the defaulting party, the defendant, is such as to lead a reasonable person to conclude that he no longer intends to be bound by the contract. In other words, it's an objective test. The court will make such an inference from the words, the actions or omissions of the person who made the promise. The intent, okay, must be objectively, clearly evident. So as I mentioned previously, if the renunciation occurs before the time for performance, it is called anticipatory repudiatory breach. What happens if the renunciation, that means when he says, I don't want to do it, what happens if the renunciation occurs at the time specified in the contract for performance? Well, it is an actual breach. So the plaintiff, the innocent party, can elect to discharge the contract. He can cancel the contract. There is another type of repudiatory breach due to impossibility arising from the disablement of the defaulting party, the defendant. That means the defendant, the defaulting party, does something to make it impossible for him to fulfill his obligations under the contract. For example, in the case of Universal Cargo Carriers and Chitati, Chitati hired a ship from Universal Cargo Carriers. Chitati was supposed to nominate the location of the ship to be berthed, the particulars of the cargo to be loaded onto the ship, the party who is providing the cargo, but he failed to make the nominations within 3 days before the deadline. Universal Cargo terminated the contract on the basis that it has become impossible for Chitati to fulfill its obligations under the contract without the contract being delayed. The court found that Chitati's actions of not providing the nominations by the due date, the court found that it rendered it impossible for Chitati to complete its obligations under the contract. So that is situation 2 for you, renunciation. Thanks for watching this video. Stay tuned for situations 3A and 3B.